I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
Filing an eviction should not be complicated. There's got to be an easier way.
Nothing frustrates me more than having to wait for my attorney to call me back. I need them now.
What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
Hello, everybody. I'm Melissa Parham. I'm an attorney with Zona Law Group, and I have Scott Baluha with me here today, also an attorney with Zona Law Group. The focus of my practice is manufactured housing communities and RV parks, and Scott also assists in those areas. Scott, you want to introduce yourself a little bit?
Sure. Thank you, Melissa. I'm Scott Baluha. I'm an attorney with Zona Law. I've been here for about 3 or 4 years. I primarily focus on assisting Melissa with everything associated with the MHCA, the manufactured home communities, as well as RV communities as well. The focus of today's podcast is to discuss a lot of the different leases that could potentially arise depending on what type of units you have in your community and whether or not they're owned by the resident or owned by the park. In addition, with RV leases, whether or not those leases should be short-term or long-term, depending on what the parties are working on. So, Melissa, do you want to start us off on the differences between park-owned homes and resident-owned homes?
Yes, and the difference, it's pretty obvious when you talk about who owns the home, but if you've ever been to an MHCA training that I teach, we start off with what's the definition of a mobile home, and then I go into explaining all the different possible laws that can govern in a mobile home park based on who owns the home, what type of home it is, and the length of the tenancy. So whenever you have a tenant come in, that's really those are the most important things to figure out. What is the unit, who owns it, and what's the length of the tenancy? So a park-owned home, that's the situation where the community owns the home. The community is renting that dwelling unit and the land out to the tenant. So the same person owns the home and the land, and they're renting the home and the land to the tenant. That's a park-owned home. That type of tenancy, landlord-tenant relationship, is governed by the Arizona Residential Landlord and Tenant Act. That's the same act that governs apartment communities or single-family rental homes. And it's very important that if you have a tenant in a home that the community owns, that relationship be documented with the correct rental agreement, which is going to be a rental agreement for a park-owned home that's governed by the Arizona Residential Landlord-Tenant Act. Because for tenant-owned mobile homes, we have a completely separate act that governs, which is pretty different from the residential act. We have the mobile home parks, Arizona Mobile Home Parks Residential Landlord-Tenant Act. Very different obligations, completely different sets of notices, and very different rental documentation. Some of the biggest differences are, for one, for a park-owned home, the community is tasked with maintaining the unit. So if the toilet gets horribly clogged, it's the community that's going to be dealing with that. Whatever other problems arise in a home, it's the community. The air conditioning goes out, it's the community that's going to be fixing it. Again, very important to put that tenant on the correct rental agreement. Scott, do you want to talk about issues that we see when tenants are placed on an incorrect rental agreement and they're in a park-owned home?
Sure, Melissa. And many of you out there may have seen me, appearing on your cases in court, and it's frustrating in the circumstance that we end up getting what we believe is a case where the resident owns the home, but it's actually a case where the community owns the home. And as Melissa said, there's completely different implications with both. So what do we do in the circumstance that the lease that was actually written is different? Well, if the inappropriate notice has been served, then sometimes we can fix that. And it really comes down to whether or not the notice that you served provided additional time above and beyond whatever the correct act applies. So let's, for the example associated with, you served a 1430 non-compliance notice believing that the lease was a resident-owned home, right? But it was actually a park-owned home. So under the Residential Act, you would have 10 days to cure a noncompliance. In this circumstance, you've served a 1430. So you've actually given the resident more time than what would have been allowed under the law. In that circumstance, most courts are fine with the implications of that, because now the resident wasn't harmed as a result of it. But now let's take the opposite. Let's say that you ended up serving a 10-day notice believing it was park-owned, but it was actually a resident-owned home. Well, I'm going to tell you right now that case will get dismissed, because if you've given the resident less time than what they otherwise would have been allowed to, then that's kind of that will be a problem, and the case will automatically get dismissed.
Yeah, and I'll see clients too who, for some reason, will sometimes just use a 1430 for every type of tenancy because it gives so much time. So when you're giving enough time, oh, maybe it works. It just creates confusion in court too, and a chance for the tenant to claim that the Mobile Home Parks Act applies and can cause a whole host of problems. And we already see enough issues with having to explain to the judges which set of laws applies when you're dealing with a mobile home park. You don't want to present a case with a residential lease and then a 1430 served, and sometimes we'll see other random notices thrown in there as well. Right. It just creates confusion in court.
Right, and that is one of the hurdles, because a lot of the times the judges will take a look and they'll see, XYZ Manufactured Home Community LLC on it, and then they'll make the assumption that, well, it's obviously a mobile home, so the Mobile Home Park Act applies. Well, that's just not true, and then we have to walk through it. So then add on to that the additional layer of explaining that, well, maybe the wrong notice was served, but it was given more time. So having to walk through all that, we always try to encourage the clients to make their files as clean as possible, because you want to make sure that you're capable of enforcing whatever legal rights that you want under the notice. And of course, any notices that you end up serving, you want to make sure that you're doing it properly. But if you have any questions about that, please reach out to our office and we'll be able to assist you with it.
Yep. Yeah. And some of the big differences between residential and park and tenant owned and park owned home, other than obviously who owns the home, who's responsible for maintenance. We have differences in the laws regarding security deposits. For example, for a mobile home space renter where the tenant owns the home, the park owns the land, which is your typical mobile home park landlord-tenant relationship. The security deposit, if the park takes one, is required to actually accrue interest at 5% annually, either paid out annually or compounded annually. So that's a big difference. If you're taking a security deposit and it's a tenant-owned unit, that security deposit has to accrue interest. That's not the case if it's a park-owned home. So that's another big difference between those two sets of laws. And as Scott mentioned, all the notices are different. So for non-payment, for a park-owned unit, a rental home under the Residential Act, you're looking at a 5-day notice, not a 7-day. Non-compliance, you're looking at a 10-day notice for a park-owned unit rather than a 1430. Non-compliance affecting health and safety, you're looking at a 5-day notice rather than a 1020 notice. And that's one of the biggest cases where I hate to see a park make that mistake and serve a 1020, because a 5-day is a whole lot faster if you've got a health and safety concern and you're trying to get someone out. Scott, what notices am I forgetting? And immediate works pretty much the same, right?
Right. That's one of the benefits of the immediate notice, is that regardless of which act that it falls under, there's a very similar language under both that puts the resident on notice about what has constituted their immediate breach, their breach of the lease agreement, which calls for their immediate removal from the property. So, that's one of the ones that we don't worry as much about. It's just, as you had mentioned, the health and safety one. We don't want the community to miss out on an opportunity if there is something that has that affects health and safety, because if you have to restart that process on a health and safety, you might have other residents in the community which might be upset about that.
Right. Yeah. Health and safety issues. You hate to waste any time messing around with the 1020 notice if it could have been a 5-day health and safety termination notice. And the way that works is really they have 5 days. So assuming it's a park-owned home, you determine what the health and safety related problem is. Now, sometimes it's something inside the home, in which case to get into the home, you're going to have to serve a 2-day notice of intent to enter, and then not set the enter date until after those 2 days expire, which I always find, I figure it's got to be very frustrating to be a manager, because if you're sending that certified, then not only are you having to pick, at least 5 days out, then you have to go 2 extra days before you pick your time to enter. And then if there ends up being a problem, and maybe you can talk about what happens if the tenant denies access for a park-owned home. But you have to first get into the home to be able to get photographs of whatever the issue is for the health and safety concern. One we'll see a lot with park-owned units are, maybe not a lot, but bed bugs or very severe roach infestations or other bug infestations, and the property has to serve that that 2-day notice of intent to enter, get in there, get a pest control guy in there or someone in there to take photographs so we can prove the issue when it comes down to it later. And then serve the 5-day health and safety after the property has the proof, wait the 5 days, and then go back in and get more photographs to prove that the condition still exists. So it's still a process, but that 5 days is still going to get you there a lot faster than the 1020 process, which is just going to create confusion. And Scott, what do you do if you have a park-owned home and you give that 2-day notice of intent to enter to go take a look at a health and safety issue and the tenant doesn't let you in?
So what our office generally recommends in those circumstances is that you're going to want to serve 2 of those notices. Be denied access twice. Then we can move forward with an eviction based on the failure to grant access on those 2 occasions. And that's mostly out of to err on the side of caution, because we don't want the residents to come to court and then potentially assert the defense that, well, there was something that prohibited them the first time from granting access. And certainly, we want to give as much leeway as we can, but again, that's counterbalanced against the interest of moving forward as quickly as you can on a health and safety issue, especially if it has implications for neighbors. In some circumstances, it's a pest infestation. So we want to control that as quickly as possible so we don't run into the circumstances that the neighbors end up having a problem as well. So you have to weigh all those interests before figuring out how to proceed. And again, our office can give guidance if there's something that you're unclear, if it falls on the line. Let's move on to the differences between the long-term RV leases as well as the short-term RV leases. Melissa, you want to start us off there?
Yeah, so this is definitely another big area where we see a lot of confusion. And again, this is why at the start of every MHCA class, I explain you want to figure out what is the home, who owns it, and what is the term of the rental agreement going to be. So when you're dealing with a recreational vehicle that the tenant owns, not a recreational vehicle that the community owns, so a tenant-owned recreational vehicle, you have 2 options for what set of laws you're going to fall under. So the law changed a few years ago with regard to park models, where it used to be that if you had a park model that a tenant owned and they rented a space and they stayed under 180 days or less, so they rented it month to month, for example, it used to be the case that could fall under the general landlord-tenant laws, which govern commercial tenancies. That's no longer the case. Under a change in the law about 2 years ago, park models, when the tenant owns the park model and that tenant occupies that park model, or their park model occupies that space for over 180 days, regardless of what the lease says, even if it says it's month to month, they're going to fall under the long-term, the Arizona Recreational Vehicle Long-Term Rental Space Act, the Long-Term RV Act. So generally, anytime you have a tenant-owned park model, they're going to fall under the Long-Term RV Act. And then also, anytime you have a tenant who owns any other type of recreational vehicle, so travel trailer, motorhome, fifth wheel, camper shell unit, any of those types of recreational vehicle type units, if they rent the space for under a rental agreement for over 180 days, then they fall under the Long-Term RV Space Act. So they're renting an RV space in an RV park for over 180 days. They're going to fall under the Long-Term RV Space Rental Act. And again, that's for RVs only. If a tenant who owns their own RV, they rent the space for 180 days or less. And I know that's confusing. I recommend not doing a rental agreement for exactly 180 days. Also, don't do a rental agreement for 6 months, because I've had clients do that. And then when we ran a date calculator, we determined that it ended up being 182 days for, in that year. So don't just do 6 months. I recommend, if you want to fall under the General Landlord-Tenant Act, the commercial laws, do a rental agreement that's month to month or maybe 3 months at a time, but don't do right at 180 days. But if it's 180 days or less, and it's the rental of an RV space in an RV park for an RV, not a park model, that falls under the General Landlord-Tenant Act, the commercial laws. And Scott, do you want to address maybe some of the differences between those laws and why it's very important that if you want to fall under the general laws that you make sure you do, maybe why those are a little more favorable to landlords?
Well, there's a very specific reasons why the residents and tenants in this particular circumstances would choose one over the other. If you're in the tenant's shoes, you may not want to bind yourself to a long-term, commitment agreement at that particular property. If you're the landlord, you may want a shorter agreement to allow the people to remain on a month-to-month basis. The key issue here is that there's a great deal of additional protections for a tenant in the circumstance that they sign off on the Long-Term Act. You're not allowed to unilaterally terminate the agreement unless you give, of course, the 90 days notice. Some communities have arrangements where they go on a seasonal, where it's 3 months at a time. Those would fall under the General Act. Probably one of the biggest confusions that we end up getting when some of these cases end up going to court is that trying to explain to the court that under the General Act, there's not nearly as many protections for tenants in those circumstances. And the analogy that I always have to give to try to help alleviate that, because the judges are used to seeing, apartment complexes, are used to seeing single-family homes, they're used to seeing the Residential Act that provides a great deal of protections for tenants. So is explaining that, well, if somebody comes to your house and says, hey, well, I want to park here at my RV, and I'll give you for the next 30 days, is there an obligation to provide them utilities? No. Is there an obligation to provide them fit and habitable conditions? No. All it is you're giving that space for a 30-day period of time, and then after the 30 days, they can leave, or you can do another month to month. So that's probably one of the biggest differences between the two, is the mechanisms that you have if you're a tenant or if you're a resident for trying to terminate the agreement is different. So
when I teach these classes, I try to explain basically that for a short-term RV space renter, someone who's just renting month to month, everything is really dictated by the contract. Again, it's the same laws that govern commercial tenancies. So if you've ever dealt with renting like a commercial office for your business or anything like that, those leases sometimes are very long because the laws that govern commercial tenancies and that govern short-term RV space rentals, they're short. I mean, that entire set of laws fits maybe 10 pages, if even. Right. Whereas the Long-Term RV Space Act, I think, is probably at maybe 30, 35 pages now. The Mobile Home Parks Act is even longer than that. So we're dealing with a set of laws that govern short-term RV tenancies that don't say much. Like you said, there's nothing about utilities. There's nothing about security deposits. There's nothing limiting late fees. And a tenant can be non-renewed with just 10 days notice before the expiration of the current rental agreement. So everything's dictated by contract. So be careful also with what contract you use when you're dealing with a short-term RV space renter, because that's going to dictate what the relationship is. You want to be sure that you're okay with what's in your contract as far as what benefits you're giving the resident, what kind of notices you have to give the resident, that sort of thing. The Long-Term RV Act is much more a little more tenant favorable, actually much more tenant favorable. And you mentioned the 90-day non-renewal notice. That's correct. So you can non-renew most types of RVs. So travel trailer, motorhome, any type of RV can be non-renewed with 90 days notice before expiration of the rental agreement, but except for park models. So there's an exception for park model space renters, since their home, we think the legislature's thinking is that that home is a little bit more permanent style. It's more difficult to move. They're usually skirted. It's a whole process to move it. They cannot be non-renewed with a 90-day notice. They're more like a mobile home space renter, where you have to have good cause to terminate a park model tenancy. But really the short-term laws are absolutely the most landlord favorable. So if you want to be able to easily non-renew tenants in your community, if you have problems and you don't want to have to spend a whole lot of money fighting in court and that sort of thing, you probably want to put those RV space renters on a short-term RV space rental agreement.
Right. Well, thank you for all the very helpful information. I guess the bottom line here is if you're an on-site manager and you have these different types of leases, just make sure that you're very careful about which ones you put the residents on, so that you understand what the rights and obligations of the parties are. Thank you, Melissa.
Absolutely. Always figure out what type of unit you're dealing with, who owns the land, who owns the unit, and the length of the tenancy, because all of those things dictate what forms you're going to use and how the landlord-tenant relationship will work.
Wonderful. Thank you again, Melissa.
All right. Thank you.